One of the reasons this topic is very difficult to discuss is because many of the women who are affected are anonymous and they can't speak out. And that's why we, as lawyers who are working with them, it's so important that we do speak out about the issues that they face. I saw a piece yesterday which referred to the sad alphabet of women that have trawled through the Irish courts, the courts in the Republic of Ireland, since the 8th Amendment to the Constitution in 1983. And any of you who know about Irish constitutional law will know that there's a whole series of these cases, ABC against Ireland, the X case, the Y case, and so on. And behind those initials are women who have pretty horrific stories and whose stories often aren't heard. And it's quite difficult for them to get media coverage also about the importance of the issues, also an issue faced by women who are subjected to domestic violence, an issue Women's Aid deal with very regularly, about how you can get media coverage when you don't have a story, you don't have a face. So that's just an important thing to say. And I think having heard the incredibly powerful testimony from Zoe and Jenny, you can really see how brave it was for them to say what they said. And as I go through this, I'll be looking at some women who have decided to put their head above the parapet and to speak out about their abortions. I think the fact that people don't speak out about it tends also to perpetuate the stereotype which exists in Ireland and Northern Ireland about what a woman or girl seeking an abortion is like. There's a kind of stereotype of a feckless 15-year-old who's using abortion as some kind of contraceptive. That is genuinely something which is said on a very regular basis. And because people don't hear the stories, they don't see the statistics, they don't know that the vast majority of people who secure an abortion are mothers already. They don't know often about the mental health and physical issues and social issues underlying the decision. So what I intend to do today is to run through three things. So I'm going to run through some little context, first of all, then I'm going to talk about some current key cases with some of those anonymous women, and then I'm going to talk about Ireland. My brief was Northern Ireland, but I can't resist mentioning very briefly the Republic of Ireland. You may have noticed the badge, and there's a referendum tomorrow, so I do want to just mention that, but I'll do it very quickly and at the end. So context. So first of all, last year was the 50th anniversary of the Abortion Act 1967, which is an important anniversary, and it was rightly celebrated. But it was also a very stark reminder of how one particular part of the UK is lagging behind disgracefully in reproductive rights terms, because Northern Ireland is still governed by primarily the Offences Against the Person Act 1861, half a century on, because the 1967 Act applied to England, Wales and Scotland. Now that's something that hasn't been very widely known, and I think there's been superb work done by many of the campaigning organisations who've worked on this issue in relation to Northern Ireland in the last year in particular. I see Polly here from the London Irish Abortion Rights Campaign, for example. So people have done a lot to raise attention for this issue. But just want to show you an example. You may have seen the protests outside the Polish embassy a year ago about stricter abortion law in Poland. And if any of you saw the coverage, you will have seen women and girls, English, who rightly went to protest about the rights of their Polish sisters. But when they were interviewed and they spoke about how concerned they were about Poland, there was a total blind spot for many of them about the fact that on their own doorstep, within the UK, there already are laws in place which are as restrictive, in fact more restrictive, than those which were proposed in Poland that they were protesting about. Now, another one of my pet topics is Brexit, and Northern Ireland having been a blind spot in relation to Brexit. I think the Northern Irish border causing a problem in relation to the Brexit negotiations is something which many of us did predict. And a large part of the reason why it wasn't predicted is because Northern Ireland often is ignored. When you look at, for example, coverage of the London riots a number of years ago, it was quite common to see on the BBC, in newspapers here, people saying this is the first time water cannon is being considered for use within the UK in 5 decades. And you think, well, no, it isn't. You know, there's a key part of the UK where this is happening all the time. And this summarises for me that blind spot with the Northern Ireland issue. So many of you will have seen with the Olympics, Team GB, which obviously must have gone through multiple layers of decision-making without anyone spotting that GB is Great Britain, that's England, Wales and Scotland. It excludes Northern Ireland. It should, in fact, be Team UK, but I think by the time I and some other zealots on this issue spotted it, it was a little late for a rebranding exercise. But that does summarise part of the problem. So, about international standards, I just wanted to flag as part of the context some of the international standards which apply in this area. I know many of you have real expertise in this field, so excuse the fact that this is quite a quick canter through. International human rights bodies have repeatedly made clear that criminalisation of health services which only women require, including abortion, is a form of discrimination against women. And the Committee on the Elimination of Discrimination Against Women has repeatedly recommended that states remove all punitive provisions for women who've undergone abortion and ensure access to lawful abortion. And the UN Committee on the Rights of the Child has also highlighted the particular issues for adolescent girls' reproductive rights and has recommended that states ensure access to safe abortion and post-abortion care services, irrespective of whether abortion itself is legal. Now, and in a number of decisions, they've looked at areas where particular parts of a country don't have access to abortion care. And they have said it's critical that in those situations when a woman has to travel or a girl has to travel, that she gets post-abortion safe care. Now, very broadly speaking, the standards on reproductive rights internationally are phrased in this quite general way. And that's why it's important to also remember that there are international standards on violence against women which are much, much more specific in relation to, in particular, women who are pregnant as a result of rape or incest, so pregnant as a result of gender-based violence. And I've just given you 3 examples here. The first one is that forced pregnancy is now a crime against humanity under the Rome Statute, Article 7. The Convention on the Elimination of Discrimination Against Women and the Istanbul Convention, which was ratified last year, says that the due diligence obligation requires states to take active steps to protect women from the consequences of gender-based violence. And there was a real open question about whether that would include a positive obligation to ensure that a woman had access to abortion in circumstances where she's pregnant as a result of rape or incest, as a result of sexual violence. And that's become clearer as a result of General Recommendation 35 from the Committee on the Elimination of Discrimination Against Women, which was actually a document which was put together by many very brilliant women, including women at the Centre, including academics at the LSE, and also one of my colleagues, Kaina Yoshida. And paragraph 18 of General Recommendation 35, the text is quite small, so it might be hard to see, but that is critical, paragraph 18, because it says that violations of women's sexual and reproductive health and rights, such as forced sterilizations, forced abortions, forced pregnancy, criminalisation of abortion, denial or delay of safe abortion and post-abortion care, and forced continuation of pregnancy are forms of gender-based violence, and depending on the circumstances, they may amount to a violation of what we know as Article 3. Now, that's critical because, first of all, the documents to date had suggested that criminalisation of abortion is a form of discrimination against women. So that's as high as it had gone. And what we now have in the violence against women standards is a recognition, first of all, that where you have forced continuation of pregnancy, where the pregnancy results from sexual violence, that in itself is a form of gender discrimination, but also it's a form of gender-based violence itself. So that's quite a significant provision. And also you'll see the phrasing refers to criminalisation of abortion itself being a form of gender-based violence. And that goes much, much further than what we had previously, because that would include criminalisation of abortion regardless of the circumstances of conception. So that's a really critical document, which I'll come back to. So in terms of the legal position within Northern Ireland, just a very quick outline. So under the 1861 Act, there's a penalty of up to life imprisonment for both the woman undergoing the abortion and for an individual who assists her. And there's a very, very limited defence under a piece of legislation from 1945, which is that under 28 weeks, there's a very limited exception, which is simply to preserve the life of the mother. So the focus is on the life of the mother, rather than on the health of the mother, the mental health of the mother, the autonomy of the mother, her decision-making. So the result of that is that the abortion regime in Northern Ireland is one of the most restrictive in the EU and in the Council of Europe, and it's actually one of the most restrictive worldwide. There are a small number of states which have the death penalty for abortion, which is quite a concept to get your head around. But apart from that, a life sentence for abortion is very, very extreme and places Northern Ireland very high up the league table of states who have quite shameful positions on reproductive rights in relation to women. It's much worse, for example, than in the Republic of Ireland. Maximum sentence in the Republic of Ireland is 14 years. It's tied to rape. So one of the phrases which is often used in by campaigners in Northern Ireland is that if you have a woman who's been raped and is pregnant, if she secures an abortion, she's subject to the same type of criminal penalty as her rapist. And that's the position. I appreciate this is very heavy going for this time of the afternoon, but I was asked to talk about it, and I think it is really important that we're aware of it and that we own it. This is happening on our doorstep, and I think we do need to do something about it. Mr Justice King, in one of the cases, referred to there being a steady stream of pregnant women who travel from Northern Ireland to England. It's almost always England, every year. And the figures had been pretty steady at about 1,000 per year. But the Family Planning Association in Northern Ireland has estimated that actually many people give false addresses because of shame and stigma, so the number is probably much higher. There has been a definite reduction in the last number of years, but what the experts in Northern Ireland think is that that is linked to women choosing to take abortion pills and therefore putting themselves at risk of criminal sanction. So until last year, there was also a bar on accessing NHS services for women who travelled from Northern Ireland to England. So again, many of you are experts in the room, so excuse this being quite simplistic for those of you who know it very well. But under Regulation 3 of those particular regulations, the position was that women and girls resident in Northern Ireland seeking abortion services in England can't receive such services on the NHS unless there was an emergency. So the position, very broadly speaking, under devolved healthcare is that in emergency situations, if you're travelling from Northern Ireland to England, you can receive healthcare on the NHS. So if you're visiting for the day, you get hit by a bus, it's a road traffic accident, that's an emergency, and you can get treated. There's some rare other examples, some particular aspects of mental health, but everything else is put into the same category. So a woman in Northern Ireland, in circumstances where abortion is criminalised in Northern Ireland, which is recognised internationally as being a breach of international standards on women's rights, a woman who has no choice in those circumstances but to travel, was put in precisely the same position as a woman who decided that she wanted access to a fully elective medical service, which she could have in Belfast, but decides she'd rather have it in London. So it's put in exactly the same category as someone who decides they'd like to have their dental care done in London, or they'd like to have a breast augmentation done in London. And they were put in the same category. So there was no distinction. There was simply emergency or fully elective. And in between, there was nothing. And abortion was put into the elective. It's one of those non-emergency issues. So that's the background. Now, also, Northern Irish women were at particular disadvantage because actually, if there's women resident outside the UK who don't fall within the responsibility of any other primary care trust, so for example, a woman travelling from the Republic of Ireland or from Malta, in theory, they can actually access NHS services on a charge-back basis. But Northern Irish women are actively prevented from accessing NHS services. And a very wonderful woman called Maura Clark, who is the voice of many of these women, she runs the Abortion Support Network, and she has said on a number of occasions that the combination of criminalisation in Northern Ireland and barriers to travelling to another part of the UK is a class issue, and an issue which particularly hurts poor people. So the calls that she gets from people who are desperate includes people who are refugees, who may have don't have a passport, have difficulty accessing travel documents. She often gets very terrified calls from members of the travelling community or other individuals who say that they are finding it very difficult to travel. And she often gets calls from terrified women who are victims of domestic violence and who say that their passport has been confiscated, they can't tell their partner that they're planning to travel. And there's very well documented evidence about in abusive relationships, control of reproduction and control of pregnancy in various ways being something which is a form of violence that's used regularly. So preventing abortion is one of those, and preventing a woman having access to reproductive choices in precisely the same way that kicking a woman when she's pregnant in the stomach in an attempt to force a miscarriage is, so that's part of the same spectrum. So many of the women who Maura deals with are exceptionally vulnerable, and women who simply can't afford to travel over. And also, it's more expensive the more vulnerable you are, because of course if you are, like one of my clients, who I'm going to mention in a moment, a child who's pregnant and you need to travel, you'll need to travel with a guardian. So it's more expensive for you to travel with a guardian. Also, if you've got a health condition, which means you're not going to be able to travel over and back on the same day, you'll have to pay for a hotel. So it's something where it's more expensive the more vulnerable you are. There's also a real potential for delays before the procedure can take place. So a case I'm going to mention in a moment, my client, who was a teenager who became pregnant, is from a low-income family. Her mother's a cleaner. a single-parent family. They live in a council estate, very, very limited income. She discovers she's pregnant at 6 weeks. They immediately take the decision that she wants to have an abortion. She can't access one within Northern Ireland. By the time they'd raised the funds, which was very difficult to do for a range of reasons, because they didn't want to tell people the background, there was a real shame and stigma associated with it. They eventually raised the funds thanks to Maura Clark and a loan for an unknown purpose from a friend. And the result of it is that by the time she was able to travel, she was 16 and a half weeks pregnant. So, of course, that then means that the procedure is going to be much more physically invasive. It's actually more expensive also, of course, the later you go. So it's like chasing a moving train, you know. And also, of course, it's much more mentally distressing in those circumstances. And importantly, although the European Court of Human Rights case law on abortion is not particularly progressive, on this issue about delays, there is some useful case law. So there's a very old case from 1993 where the European Court of Human Rights referred to health risks to women resulting from such delays in open-door counselling. In that case, I don't know if there's any Irish people here, but as an Irish woman in my early 40s, hello, I grew up in circumstances where there was a ban on information. So as a teenager, I don't know if you also had this, as a teenager, if you managed to get hold of Cosmopolitan magazine or Jackie magazine, literally someone had at the back pages where the small ads were, cut out the ads about abortion clinics. It was just bizarre. So, I mean, that happened. That happened in the 80s. It happened in the 90s. So open-door counselling was a particular case about access to information. And there the European Court of Human Rights accepted that lack of access to information would have a health knock-on effect because of women not being able to travel. So that issue about the link between abortion and poverty and that intersectionality issue isn't unique, obviously, to Northern Ireland. You'll see this, this one of my favourite cartoons. So, make American women die in back alley abortions again. I've got a slightly dark sense of humour, I think. But anyway, but in the US, where abortion obviously post-Roe and Wade is legal, you can see there this impact on particular women from particular groups. So there have been recent state-level restrictions in the US in the past 5 years. And the result is that researchers from the Texas Policy Evaluation Project have estimated that this huge number of women have tried to end a pregnancy on their own without medical assistance. And if we just go back to Maura Clark's quote, I don't know if you can see that, where she quotes from one woman who was unable to travel. So she's faced with a choice of continue the pregnancy, raise the money to travel, or do something illegal, like taking abortion pills or trying some other way to end the pregnancy. And she says, I drank bleach, I took 3 packs of birth control pills with a bottle of vodka, threw myself down a flight of stairs. I've been trying to figure out how to crash my car but not permanently injure myself or die. And those of us who work with these women, we do hear that story. We hear a story about a woman trying to work out a way in which she can get the pregnancy to end but not risk damage to her own health. I mean, really horrifying stories. And that's echoed then in this material from the Texas Policy Evaluation Project. Also on intersectionality, some of you may have heard about the Jane Doe case in the US. So it's been under headlines in articles like, what would America look like without Roe and Wade? Well, these teenagers are finding out, because these are young women, teenagers, who've got uncertain immigration status, so they're in detention, and they've been prevented for moral reasons by the Trump administration from accessing abortions. And there have been a whole series of cases litigated by the American Civil Liberties Union. And again, the women have won ultimately in these cases, but instead of having an abortion at 5 weeks or 6 weeks, they have one at 20 weeks. So very similar. And similarly, there's a horrific case in Ireland called Ms. Y, who was an asylum seeker who arrived in Ireland, discovered that she was pregnant as a result of rape in her home country, which is part of the reason she sought asylum. She eventually did secure asylum. But at the time, she was suicidal, uncertain immigration status. She tried to get on a ferry because it's easier to travel on a ferry without showing a passport, but she got spotted, in part due to racism. She was much easier to spot than perhaps someone travelling without a passport who was a white woman, and she got returned. And in fact, it's an absolutely horrific case to read. She went on hunger strike when she couldn't get an abortion. And the health and safety executive got an order to hydrate her against her will. And she had a caesarean section against her will at 25 weeks. It's the most horrifying case. You read it and you think, how does this fit with all of those cases that were referred to earlier in that very powerful paper by Suzanne about autonomy and so on? I mean, just in this case, she was a vessel to carry this baby, and that was it. It's an absolutely horrific case. But that again, that intersectionality issue about how it affects women who are poor, how it affects young women, how it affects women who have uncertain immigration status is really critical, because the law in Northern Ireland doesn't have equal effect. It affects some women far, far more than others. with that cheery start, let me come on to some of the current key cases. So, first of all, I'm going to talk about 3 cases. The first is JR 76, and I'll take this pretty quickly. This is a judicial review of a decision to prosecute a mother for procuring abortion pills for her daughter online in 2013. So again, it's a low-income family, so travelling is difficult. So the mother finds a way to get the pills online and does that. Her daughter was 15 at the time and was pregnant as a result of an abusive relationship. So a much older boyfriend who was physically and verbally abusive, who threatened her and her unborn child with violence and attacked her. So after she takes the pills at home, which is illegal in Northern Ireland, there is abnormal bleeding. And her mother has seen in the material that she's got that if there's abnormal bleeding, what do? You go to a doctor. So the mother and the daughter go to the GP to report the abnormal bleeding. The daughter is very distressed. They get referred to mental health services and social services, and the family are referred to the police, because in Northern Ireland there's also an obligation, a positive obligation, that if you learn of a criminal offence having taken place, you have a positive obligation to report. So here, it was reported by the people who they went to for help to the Police Service of Northern Ireland. Personal medical information was provided to the Police Service of Northern Ireland by the GP, and that formed the basis for a prosecution of the mother. This is happening in 2018. It's absolutely shocking. So that's that case. Now, what's happened there, the mother's been prosecuted for unlawfully procuring and unlawfully prescribing a poison or other noxious thing. And the drugs are precisely the same drugs which are used lawfully for medical abortions at an early stage here. So there's a judicial review, 2 grounds. Firstly, it's a breach of the Article 8 rights of the mother and the daughter. And then secondly, there's a challenge at common law, both a kind of Purdy type point, that there's insufficient guidance for decisions to prosecute, whether that's challengeable. And then specifically in this case, they didn't look properly at the impact on the daughter of a decision to prosecute the mother. Really interestingly, and this shows you how distorted the mindset is, here the GP was made fully aware, as was social services, as were mental health services, that the pregnancy was a result of a violent relationship with this young teenager by an older man, and he was not reported to the police. So the crime which was reported was the mother buying the pills, and in fact the other crime, the sexual violence, wasn't reported. And that just shows you how distorted the mindset is here. Right, next case, A and B. So again, I'll do this pretty quickly. So this was a challenge to the bar on Northern Irish women accessing abortion services on the NHS in England, which I spoke about a moment ago. And on this particular case, poverty and delay issues were really critical. So this is the young woman who couldn't travel, the young girl who couldn't travel for a long time because of the delay in raising the funds. So it was a twofold challenge. It was a challenge under Article 14 and the common law. So the argument was that the Secretary of State's policy was incompatible with Article 14. It was a type of discrimination against a woman resident within the UK, and that an unlawful distinction was being drawn between different parts of the UK. And it was also argued that the Secretary of State had failed to discharge his duty under Section 3 of the NHS Act to meet all reasonable requirements for services listed in that section. And I won't go into the reasons just for time. So, almost a year ago, 14th of June, very narrow split in the case, 3-2. So our clients lost the case 3-2. The majority was Lord Wilson, Lord Reid and Lord Hughes, minority Lady Hale and Lord Kerr. And the majority found that there'd been discrimination against A and B, but it was justified on the basis of the importance of devolved health services, with Northern Ireland, England, Scotland and Wales each being responsible for providing free health services within their own countries. It was a very tight decision. You can see when you read Lord Wilson's judgment just how tight the decision was. But that was the key reason. That was the balancing factor which meant that actually, although it was discrimination, it was justified. And Lord Wilson said that abortion isn't different to other grave medical conditions. And there was a real floodgates argument that, well, what would then happen about some services which are difficult to access in Northern Ireland for reasons of population? Would it then lead to a huge number of people wanting to travel because they could get better cancer care in England and so on? And importantly, Lord Wilson at paragraph 35 referred to the weakness of those materials on reproductive rights as saying that the authority of the recommendations is slight. They add background colour, but you'd need material of a far more vivid hue to put into the balance against the importance of devolved healthcare services. And also, they placed a lot of weight on the fact that this was a democratic decision reached in Northern Ireland, so they were quite deferential to the Northern Irish authorities. Minority, I will say the minority was the only woman and the only Northern Irish judge So take from that what you will. But Lady Hale and Lord Kerr, they're very, very powerful judgments. They're dissenting judgments, and they both ruled unequivocally that this was a breach of the Secretary of State's duty to ensure that UK citizens present in England, ordinarily resident in Northern Ireland, who require access to abortion services should be provided with them free of charge. So they said it was a breach of Article 14, read with Article 8, and Lord Kerr gave this example here about, and this goes back to the point I made about emergencies, that a woman from Northern Ireland who suffers an acute attack of appendicitis will have her appendix removed in an NHS hospital. And why is that any different? So he saw this as being in the same category of this being necessary healthcare to provide to a woman who was travelling. And they're really very powerful judgments. So fast forward 2 weeks later, this was astonishing last summer. So 15 days later, 29th of June, we had a total U-turn on this issue by the government. So Stella Creasy, who a number of us worked with very closely, had a proposed amendment to the Queen's speech. And you may remember, because of the Parliamentary Arithmetic, the government was under quite a lot of pressure. She managed to get 105 MPs, including critically some Conservative MPs, to support her proposal. It was due to be debated that evening on the 29th of June, and in the early afternoon, out of the blue, there was an announcement that in fact the UK government would fund abortions for women travelling from Northern Ireland. The chicken licking, sky falling in issue, which was so critical 15 days ago, appeared to have been resolved in the afternoon of 29th of June 2017, and there was then a letter from Justine Greening, then Minister for Women and Equalities, that afternoon. So it seems to me there were multiple factors which led to that happening on the 29th of June. And it's a really good example for those of you who do test case work of how sometimes a loss in the courts can still result in a win in practice when you have the right factors in place. So here I think there were really 8 things. There was firstly the parliamentary arithmetic, the fact that the government was under so much pressure, so the numbers were very tight, it could have been an embarrassing defeat. The secondly, the fact that the balance of power was being held by the Democratic Unionist Party, so there had been this unprecedented focus on the DUP. And one of the women who I campaigned with in the London Irish Abortion Rights campaign was saying, everyone's just learning now what the DUP are like. I've known this for all my life. But there suddenly had been this real focus on, well, why do they say what they say on equal marriage? You know, why are they against gay marriage? Why are they against gay adoption? And so on. So there was that. So Northern Ireland was suddenly in the spotlight. Thirdly, actually, I'm loath to say this, but I do think Trump being in the White House is part of the background mood music, because there suddenly is more attention on women's rights because of the way he's been dealing with women's rights and because of what was happening with Roe and Wade and rowing back abortion rights there. Fourthly, my clients A and B, their case had actually got a huge amount of attention, and people were very, very sympathetic when they heard that story and when they saw the very powerful quotes in the press from Lady Hale and Lord Kerr. Fifth, over many years, campaigners in Northern Ireland, Alliance for Choice, Family Planning Association, had been digging away, and they suddenly had been given a platform in the last few weeks. So they were being heard in Westminster, being heard in England in a way they hadn't been before. Importantly, so this is item 6, one particular woman at the London Irish Abortion Rights Campaign was a constituent of Stella Creasy's and had been going to her surgeries repeatedly for months and saying, this isn't just an issue about Northern Ireland, it's also an issue for England because it's about Northern Irish women coming over here, and in Westminster you've got to do something about it. So another anonymous woman behind the scenes who deserves a lot of credit. And seventh, there's Stella Creasy just being so dynamic and fantastic on this and securing cross-party liaison on the topic. And then eighth, and I think this is really important, so I'm not just praising a Labour MP, Justine Greening MP was also really critical. And for those of you who've worked with her as Minister for Equalities, she's really very committed to international standards on discrimination against women. I think her being in office was very helpful. So all of those things came together and we had this issue. So Justine Greening's letter then said the funding would come from the Government Equalities Office, not NHS England. So that left a few key issues to resolve. Including, would travel be funded? Because actually paying for the procedure is not that helpful for particularly low-income women. So that issue was particularly important. And then the first one I have there about the bar on NHS services. When they told us what the scheme was going to be, it became apparent it was going to be a kind of ex gratia separate scheme where women were going to be funded to go to private abortion clinics. Now, some women can't go to private abortion clinics. So if you are at a very late stage of gestation, you've got a fatal fetal abnormality, for example, you need an abortion at a late stage. If you've got high blood pressure, there's a whole range of reasons why women need to go to an NHS setting. So we were worried then that the bar on NHS services would cause a problem. And there were some other very practical things, including women who've lost a much-loved pregnancy, return of fetal remains, and so on. a whole range of other topics. So we had a series of meetings with Stella Creasy, with Justine Greening, working this through. There is now a scheme in place, which is fantastic, but there are particular difficulties about accessing care in NHS settings, and there's also particular difficulties with women who come over to go to a clinic, and then when they get to the clinic, it turns out they're further along than they thought, or it turns out there's an unexpected healthcare issue, and there's a continuing problem with women actually getting in to hospitals. So A and B are continuing to take their case against the UK in Strasbourg. I'm not going to go through that because of time. I just want to get to the end of this, so I'll just do another 3 minutes on the next case, and that's it. So the next case is the Northern Ireland Human Rights Commission case. So that's a challenge to the near total ban on abortion in Northern Ireland and its impact on two groups of women. So women who are pregnant as a result of rape or incest, and serious fetal abnormality cases, including fatal fetal abnormality cases. So cases where it's discovered that the baby has a condition incompatible with life. And very quickly, the women succeeded in, the Northern Ireland Human Rights Commission succeeded in part in the High Court in Northern Ireland. It was found that there was a breach of Article 8 due to there not being an exception for fatal fetal abnormalities at any time and pregnancies which are the consequence of sexual crime up to viability only. They then lost in the Court of Appeal in Northern Ireland, astonishingly, on precisely the same day when there was that U-turn by the government. So in the morning, so I did a blog for the Huffington Post saying, well, all eyes now need to turn to Parliament, and let's hope Parliament give a better decision than they did in the court this morning. And it was up for about 5 minutes. So I like to think I was partly responsible. Anyway, but it was very deferential to the legislature. It was then, so an appeal was then heard in the Supreme Court in October 2017 by a 7-judge panel. Really, really interesting. And the one thing I'll pick out, just because of the time, is the international materials in this case are much, much stronger. So you'll remember the words of Lord Wilson saying you'll need material of a much more vivid hue. Well, on these topics, there is material of a much more vivid hue, because for fatal fetal abnormalities, Ireland, the Republic of Ireland, has lost a number of cases in the UN before the Human Rights Committee on it being inhuman and degrading treatment to force women to travel in those circumstances. So very, very clear on precisely the same point. And on violence against women, you've seen that paragraph that I took you to earlier, paragraph 18, about violence against women. So there is material of a much more vivid hue. Now, we're waiting for the result. We don't know quite what will happen yet. We're not there yet. But I'll just pick out a couple of things. So this was a challenge brought by the Commission. So it was a generic challenge. And the Commission partly did that because women affected in these cases often can't come forward or don't know that they've got legal recourse to come forward. But individual women were heard through evidence, including from Maura Clark from the Abortion Support Network, who I mentioned earlier, and also interventions. So the JR 76 women intervened in this case. So their case was parked, and they got to intervene, and they got 30 minutes. And this woman, Sarah Ewart, very brave woman, who decided to speak out about her being pregnant with fatal fetal abnormality and having to travel and how horrific it was for her. And she spoke out and came to court and gave a face to those many women who are affected by this law. Other unusual features of the case, more female advocates than ever before, 6 women QCs in court, which was fantastic, and just the way it lined up. All the male QCs were on one side, all the female QCs were on the other, which was quite nice. So, and it came quite shortly after the Brexit case, where you may remember Helen Mountfield having 30 minutes of submissions over the course of a 4-day hearing, and absolutely everyone else being white, male. Oh, sorry, there was one ethnic minority advocate, one woman, everyone else, just one very particular thing. So that was interesting. And then Monia Anyadika Danes QC is one of the women, and I thought it was worth showing you this. It turns out that her face speaks 1,000 words, so she actually turned into a meme inadvertently, because as submissions were being made, which were quite offensive, she was sitting there glowering, and she's not on Twitter, and she suddenly discovered she'd gone viral overnight, because so many people said she's summarising precisely how I'm feeling watching this case, which I thought was good. And then lastly, 7-judge Supreme Court, it was the first time it sat with the 2 women, with our new female Supreme Court judge. The UK obviously is one of the lowest proportions in Europe of female judges, and it is one of very odd things for those of us who do these cases on women's rights. You turn up and you're arguing these cases in front of male judges all the time, and really interesting. Having had a 100% white and until recently 91% male Supreme Court, to now finally have had a case where we have 2 women of 12, 16.6%, not great, but in circumstances where at the start of 2017 it was 9% female but 18% Robert, I think we've moved on. It reminds me of this. I don't know if anyone's seen this cartoon saying This year we made great strides by doubling the number of women in engineering. And then I can't believe there's 2 girls in our class. It must be some kind of record. So it does feel a bit like that. I'm really conscious of time, so I'm going to finish up. But can I just finish up by saying one thing? I'm not going to show this video, but I'll put a link on Twitter if people want to see it. Tomorrow is the referendum in Ireland, and the issues in Ireland are very, very similar. And I would really recommend, those of you who are interested in following this, I'd recommend you looking at the Home to Vote hashtag, where you can see people from all around the world who are actually returning. And in circumstances where Ireland has exported its women, and Northern Ireland has exported its women for healthcare for so long, I think it's really interesting that the vote may be influenced by women travelling back the other way. There were some Irish comedians, Sharon Horgan and Aisling B earlier this week said Ireland's most famous exports should be Waterford Crystal and Tato, not women. And that is very much how I feel. It's high time we stop exporting women from Ireland and Northern Ireland, and we instead own the issue and provide women with much needed healthcare at home.